Welcome back to Court TV Live. Let's go back to Florida together now and hear the arguments from the attorney representing Gabby Petito's parents in this lawsuit.
May it please the court. Your Honor, this case is not simply about the silence of Christopher and Roberta Laundrie, who knew that their son had brutally murdered Gabby Petito. It's not simply about their callous refusal, despite pleas from the Petito family, to speak up about whether or not Gabby was alive and if she wasn't, where her body was located. It's about a course of conduct that they committed from the moment they learned on August 28th of 2021 that their son had brutally murdered Gabby Petito up until the time that her body was found. And as this court has already noted and pointed out, that includes the statement that was made the one time they decided to speak up. They spoke up through their attorney, and I'll touch upon the importance of that in a little bit. As the court knows, you're bound to accept as true all of the facts alleged in the four corners of the complaint, and I'd just like to review what some of those allegations are.
Well, let me ask you this, Mr. Riley. And let's lay aside the statement that the attorney made on behalf of the Laundries. What duty did the Laundries have to do anything to help Mr. Petito and Ms. Schmidt?
That's a fair question, Your Honor, and I've struggled with the answer to that particular question, and I guess maybe by answering this I'm deflecting, but my answer is this. It's about what they did with the information that they have, not just not disclosing what they knew to the Laundries. And by the way, they could have, to the Petito family, excuse me, they could have made an anonymous phone call and said where the body was located, and that would have helped this situation tremendously. They knew, starting on August 28th of 2021, that Gabby was dead. They knew where Gabby's body was. They knew that the Petito family was desperately searching for information, but they did things affirmatively. They didn't just remain silent. Brian Laundrie came home in Gabby Petito's van by himself to his family's home. That family, knowing that Gabby was dead, knowing their son had murdered her, knowing where the body was, and in particular, knowing that Joseph Petito and Nicole Schmidt were desperate to learn where their daughter was located, they went on vacation. They assumed and continued their normal life as though nothing had happened, while this family was suffering, wanting to know what where their daughter was. Not only did she not...
Let's get back, though, to legal duty. I hear what you're saying, that these facts might sound bad, but you know, we're not talking about social mores here. We're talking about legal duty.
We're talking.
So let's try to focus in on what duty did the Laundries have? What did they owe to Gabby's parents?
Well, let's put in perspective what the relationship was, Your Honor. These people were not strangers. These people were. Their son was engaged to marry Gabby Petito. Gabby had lived with them for about a year. They had both visited Joseph Petito's home and Nicole Schmidt's home. They were cordial. They had a cordial relationship, a warm and friendly relationship. They knew how much Gabby meant to Joe and to Nicole. Going to the issue of a duty, Your Honor, I struggle with that. Admittedly, it's difficult to say what it is. And that's why I'm saying there was a course of conduct that they did that was outrageous, culminating, in my view, in the statement that was made by their attorney, who, as Your Honor pointed out, is their agent. And what that attorney said in particular is telling. So there's no question that he represented, that he was making that statement on behalf of the Laundries, because he says, it is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming on behalf of the Laundrie family. It is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. That statement was issued with the full knowledge and consent of the Laundries, with the full knowledge on the part of the Laundries that Gabby was not alive, and that Gabby's body was located somewhere out west. And instead, they make a statement saying, we hope you find her. We hope you're reunited, giving them false hope that perhaps their daughter is still alive. If that's not outrageous, Your Honor, I don't know what is outrageous. So I think when you talk about their affirmative duty to speak up, I struggle with that. But they did speak up. And when they spoke up, they made that very callous, that very terrible statement, giving hope to Joe and Nicole that perhaps Gabby was still alive, with full knowledge that she was not. And Judge, when I talk about the course of conduct, I want to talk about some of the cases that I cited in my response to the motion where the court found that there was outrageous conduct. And I don't see how any of these cases.
Ooh, these arguments are solid, aren't they? We're going to hit pause. You're not going to miss any of this. I want to bring in my guest for some reaction in the studio with me. Judge Kimberly Bando, joining me remotely, Dr. John Delatorre. Judge, you and I were watching this, and I want to let our viewers know we were saying, oh, wow, go ahead, counselor. That was really, really impressive. Your thoughts on the lawyering here and what he's getting at?
He's getting at the conduct, that statement that they made, knowing well that, you know, at that time she was deceased. And then you're wishing us well, then hoping that we find her. And that is outrageous conduct. That's like unpalatable, that you would wish that we find her and you already knew that. And so I think that conduct and then making that statement with the timing of it is going to be the reason why this motion is going to be denied.
Appreciate it, Judge. Dr. John, tell us what that's like, you know, for a parent, you know, to be in that position where they're holding out hope that they're going to find their daughter alive, find her unharmed, you know, and they get this information that they believe to be, you know, totally false. You know, I mean, they're basically saying, pants on fire, Laundries, you know, you lied to us, you did us dirty, you know, we were holding out hope that our daughter was going to be found, and because of you, we suffered. What's that suffering, you know, look like? Help us understand what they likely went through.
Well, it's a betrayal, right? They feel absolutely betrayed. And here's the distinction between, you know, having a psychologist talk about this and having a lawyer talk about this. And it has to go with the judge's question about, well, what duty did they have? You know, whether licensee, invitee, trespassee, that none of that matters in the minds of the Petitos. They felt that this was a relationship that they believed to be strong, to be healthy, right? They were going to join families. So they believed that in the truthfulness and the authenticity of their relationship. So they believed that they would be receiving all of the important information that they knew, right? That the parents of Brian Laundrie knew. And apparently they didn't get that.
Right, right. Thinking about what they had to have gone through, you know, and from that perspective, I appreciate it, Dr. John. You know, they're looking at them as like future family, right? They're the mother and father of the man who's going to marry their daughter. And when they were saying they were blocked, like blocked by way of cell phone, blocked on social media like Facebook, and just felt like, oh my gosh, I feel so helpless. I'm trying to reach out to you and you won't communicate with me. What does that say to you about the Laundries, the fact that they cut off the communication, didn't even make it possible for the Petitos to do it at one point?
It's insulating themselves, right? What they're making sure that they do is that they don't reveal any information that might get their own family in trouble, right? That I'm pretty sure in their minds they thought what's done is done, right? Unfortunately for the Petitos, they don't know, right? So they're out there lost, they're out there confused, they're out there feeling betrayed by the people that they thought were supposed to be, you know, on their side, while the Laundries are out there thinking, no, we have to insulate ourselves, we have to protect ourselves.
Exactly. I really appreciate the perspective, Dr. John. And Judge Kimberly, finally, before we have to go to break, if you had to make a prediction here, what the court is going to do, you're pretty sure the judge is going to say, we're denying this motion to dismiss. This lawsuit's going to keep proceeding.
I think at least now he's going to let it continue. That's my prediction.
Mm-hmm. And you say that because, was there something in particular that jumped out during the hearing that made you think, oh, okay?
Yeah, just based on the questions that he's asking. So I can tell his concerns are, one, that affirmative conduct was actually happened as alleged, and then also that his concern is about the duty, like what legal duty did they have, and so those are where he is. And I think that based on what the attorney just argued, that it's going to be successful in basically having the case to continue to go forward.
Judge Kimberly Bando, Dr. John Delatorre, always great to talk to you both. Thank you kindly for all of that. We are going to squeeze in a break. When we come back, we'll go back in and hear more from the Petitos attorney. For staying with us here on Court TV Live, I'm Julie Grant. Let's go back into the courtroom together. Now we're in Venice, Florida, covering a hearing where the Laundrie parents are trying to dismiss the lawsuit filed against them by the Petito parents. Right now, the attorney for Gabby Petito's mother and father is speaking to the court, making some serious arguments. Let's listen.
Stretch of the imagination, worse than what happened in this particular case. In the McAlpin versus Sokole case, a patient went to a hospital to have an x-ray done. She put on a hospital gown. She walked into the x-ray room, and the minute she walked into the room, the doctor began berating her in front of other staff because she hadn't paid another doctor's bill. He told her he wasn't going to treat her, and he told her that he was going to call security and have her removed from the hospital. That, according to the court, was outrageous. In Nims versus Harrison, a teacher, two students of a teacher wrote, published, and circulated a newsletter in which they had an article called Low Life, and they referred to that teacher in offensive language, threatened to kill her, threatened to rape her children, and threatened to rape their cousins. Outrageous. Ford Motor Credit Company versus Sheehan. Collection agent is unable to locate the debtor, contacts the debtor's mother, tells the debtor's mother that she's from a hospital out in California. She's trying to locate the debtor because two of the debtor's children have been in a serious car accident, and she wants to find the debtor so that she can let him know about this accident. The son speaks to the mother later that day, hears the story from the mother, spends the next 7 hours calling hospitals and police departments out in California, only to find out that this story was false. That was outrageous. The Dependable Life Insurance Company versus Harris case was talked about previously. In Liberty Mutual versus Stedman, the company delayed authorizing a lung transplant even though a judge of compensation claims had already ordered that they pay for the lung transplant. The carrier knew she would die without the lung transplant, so hoping the problem would go away, they denied payment in an effort to intentionally induce stress on her part to speed up her demise. The court said, under the totality of the circumstances, it's outrageous. Williams versus Mineola, and it's these two last cases that I'm going to cite the court to that I think are most instructive here. In Williams versus Mineola, police officers attended the autopsy of a teenage boy who had been murdered or committed suicide, and they were there with a videotape, a video camera, and a camera to record it because of the suspicion that a crime may have been committed. They took that video, they took those photos, and they took them to a party. And at the party, they shared them with other persons, including other police officers from surrounding jurisdictions, and they laughed and they joked about what was in those photographs. The court found that to be outrageous, and here's what the court said. As for what is outrageous or reckless or what is not, we emphasize that our society, as reflected, for example, in decisions of the courts of Florida cited earlier in this opinion, shows a particular solicitude for the emotional vulnerability of survivors regarding improper behavior toward the dead body of a loved one, and the special deference paid by courts to families' feelings where rights involving dead bodies are concerned is central to our decision. This area is unique, and once it has entered behavior which in other circumstances might be merely insulting, frivolous, or careless becomes indecent, outrageous, and intolerable. One obvious reason is that the bereaved are already suffering psychic trauma because of the loss of the loved one, and are especially sensitized to any disrespect or indignity directed at the deceased body or a representation of it. The potential for severe emotional distress is enormously increased in that situation. All of this is well known to the ordinary person, and so a level of carelessness or callousness which might not be considered tortious in other situations can show outrageousness and recklessness when a dead body or a picture of a dead body is involved.
Well, Mr. Riley, how is a statement, "We hope this search is successful," how is that in itself outrageous?
It's a lie. It's said with knowledge that there's no hope of finding her alive because she's dead. It's said with an intention to give false hope to a family that their daughter may be alive. That's outrageous. And at this particular point in time, they had been begging the Laundries to tell them where their daughter was, and this is the statement that they issued. The one time they chose to speak up, this was the statement that they issued. A lie that gave false hope to Gabby's parents that perhaps she might be alive. The other case, Your Honor, that I think is instructive is the Thomas versus Hospital Board of Directors case, and I think this one may be even more instructive. In that case, during I believe it was a hip transplant surgery, the decedent died. She died of cardiac arrest. What she really died, the real reason she died of cardiac arrest is because she was given an overdose of a particular medication during the surgery. And the doctors and the nurses agreed that they would not report the true reason for why she died. They would say that it resulted from complications of surgery. As a result, a complete autopsy was not done. The body was released to the family, and less than a week later, as the decedent's daughter was trying to bury her mother, she received a telephone call from the medical examiner saying, "You need to bring that body back immediately. We have to perform a complete autopsy." Again, the court said that was outrageous, and what the court said was, "We believe that the appellee's conduct in making false statements," and isn't that what Mr. Bertolino did on behalf of the Laundries here? "We believe that the appellee's conduct in making false statements which led to the interruption of Mildred Thomas's funeral and the return of her body for a second, more thorough autopsy rises to the level of atrocious and utterly intolerable behavior which cannot be condoned in a civilized society. As noted in Stedman, when an actor has knowledge that the other person is peculiarly susceptible to emotional distress," and the Laundries knew that because this family publicly said they were distressed trying to find their daughter, "the actor's conduct may become heartless, flagrant, and outrageous when the actor proceeds in the face of such knowledge. We believe that in a situation where a person's loved one has died, it would be apparent to anyone that the person would be susceptible to emotional distress, and therefore that the action of providing false information concerning the loved one's cause of death meets the standard for a claim of outrage." In this case, they provided false information, a false impression, knowing that Gabby was dead, that she was still alive and she could be found by the family if they were searching in the right place. So I also think under the restatement of Tort Section 46, comment F says, "The extreme and outrageous character of the conduct may arise from the actor's knowledge that the other is peculiarly susceptible to emotional distress by reason of some physical or mental condition or peculiarity."